Leonard SN, your submissions are very, very interesting, and we're learning from them. You served us a letter from your chambers today. The last paragraph is advising us to halt proceedings because you've gone to the Court of Appeal. We take it that this is also an order from the Court of Appeal? Yes. Yes.
Seeking for an order to stay proceedings, that those proceedings should be respected, and the Court of Appeal given an opportunity to determine one way or the other where to go. A ruling against us will not stop the Court of Appeal from proceeding. They have the jurisdiction inherently to reverse what this court has done, but we don't want to take it to that level.
You know, Leonard Senior Advocate. Yes,
sir.
The mere filing of a matter at the Court of Appeal.
No, it's no longer mere. It's a serious vote of fault.
You have filed a motion. You have filed a paper. You have filed papers at the Court of Appeal, right?
The Court of Appeal and the authorities I have here say the mere, let's use the word mere, filing of those papers, enjoin with respect these honorable tribunals will tarry a while. It's not tarrying forever. To tarry a while until they decide. They are our senior brothers. So if they say we are wrong, I can be castigated for that. So but let us respect the processes that are there.
In other words, you want to say that you are the one that prevent your client from coming, just based on these arguments you want to come.
No. That would be like putting an illicit substance in my pocket and calling the police at the same time. My client is an adult. He's independent. He instructs me.
Why can't he come?
Well.
Why can't he come?
Yes.
So that these issues that you are raising can be combated in his presence. Why? If he's not running around from anything.
He is not. And I don't want that impression to be conveyed.
Sure.
If he's running away, he won't send us. But if your lordship...
Sending you is different thing for him to appear personally.
Yes. If this honorable tribunal...
He's a very important person in the country, and we expect him to obey the rule of law.
And indeed, if he comes, because of his importance and his stature, you're not going to do anything much to him. You know that he is not going to... but the law is the law. We're all bound by the Constitution. He has the right to appeal, he has exercised. Whether or not the ACJ applies...
Did you know that for even you to begin to make any application on his behalf, ordinarily, in legal, in matters like this, you ordinarily be present before you make such kind of applications.
If we follow if you have ruled that the ACJ binds us,
yes,
and we appeal and we are unsuccessful, that's only when I will be prevented. But so long as we are still making submissions, and you know, my Lord, that's what both of us all went to school to study, to learn how to make these submissions. And so we are making them with the highest sense of responsibility.
The truth of the matter, he has shown a symbolic appearance. That would have sent signals. These are people.
I'm sorry, sir. Yes, sir. My Lord, sir, I know that you are relying on the ACJ Act, but you see, the law as it stands today is indeed when you have objections as to jurisdiction to plea in bar. I think we brought Edet against the state, that he doesn't need to be here. And my Lord, you recall that when Chief Olanikwekun appeared before you with the Right Honorable or Honorable Distinguished Senator Tinubu,
yes,
you dispensed at a point with his appearance. You dispensed with his appearance, and he entered the dock the first day. I followed the proceedings.
Yes.
The next time Chief Olanikwekun said they still have interlocutory objections, and he was asked, I think you were presiding.
But the fact still remains that he was here.
Yes, but he dispensed his appearance in the dock. Yes. Now, if we get to this point, I don't want to be held on to Yes. I don't want to be tied down to the Administration of Criminal Justice Act, but even Section 266 says that while we are dealing with interlocutory applications, that he need not be here. If you look at Section 266, that's what it is. He's not afraid of coming. He will come. He respects your honor and your learned member.
Learned SN, I have drawn your attention to 305. You refuse to read it. Go read 305, subsection 1B and C. Can with this provision still allow us to pander to your wishes?
And I have answered.
No, even if we don't have jurisdiction, we can still hide under this cover to still proceed. So address us on this.
I have.
Yes.
And I've said not only 305 or 306, yes, but the entire ACJA does not apply. You have not ruled.
Okay, we'll handle that. We'll rule on that.
All right. Do you want us now to address you properly with authorities?
Sorry?
Do you want us to, because we were exchanging feelers on this point. We want to go into, so that we can be properly recorded as a tribunal of record.
In the circumstance, first thing first, we will have to look at the issue of his non-appearance before us today, based on the undertaking that you have taken. No, you have taken an undertaking. Everybody is here.
I expected you ruled on that.
No, I've said it. I've noted it, and that noted presupposes that I've given you a leeway.
My Lord,
you didn't grasp what I said.
I didn't.
Why?
Because they got up to oppose. If they didn't oppose.
Yes. So we are going to rise for a while now for just 1 hour. Kindly bear with us. We will come back and deliver a ruling on the issue of the propriety of his coming or not coming.
Okay.
Then from there we will proceed.
Okay.
Please. Bear with us, eh? We will be back shortly.